Hello, my name is Edward Gross. I am the managing partner at the law firm of Gross & Romanick. Perhaps the most common question we receive from individuals looking to start a new business is, should I be a corporation or should I be a limited liability company, commonly known as an LLC? Both entities can provide personal protection to the owners if they are properly established and properly maintained. In order to make this decision, the owners need to understand the differences between a corporation and LLC. This video will concentrate on the law of the Commonwealth of Virginia. Other states may vary. In this video, I explain the differences between a corporation and an LLC. If you want more detail, there is a link in the caption of the video to a chart which compares the two types of entities. Of course, I recommend that you consult a lawyer. I will briefly discuss on taxes, but a complex discussion of taxes is beyond the scope of this video. CPAs have been the driving force behind the recent popularity of LLCs. LLCs solve several problems of a corporation. One of these problems is the potential for double taxation. A tax on the corporate profits, a tax on the distribution to the individuals. Although a corporation can make a sub-S election, the sub-S corporation does not work in every situation. Since an LLC is taxed as a partnership, unless the owners choose otherwise, it solves this problem. For a corporation, the bylaws will control how the company will operate. The LLC has an operating agreement. Shareholders in a corporation should have a shareholders agreement, while members of an LLC can put similar provisions into their operating agreement. If an LLC does not have an operating agreement, the Virginia Code will control. I don't recommend it. Virginia allows the owners of both types of entities a great deal of flexibility in the creation of these legal documents. It is advisable to have a good set of bylaws and shareholders agreements, if possible, for a corporation, and a good operating agreement in an LLC for many reasons, including ownership and management succession and protection of minority owners. The advantage of the LLC is that it requires less legal formalities. Unlike a corporation, it is not required to file an annual report with the State Corporation Commission. It is not required to hold annual meetings, and is not required to provide the State Corporation Commission with the names and addresses of its officers and directors. Therefore, the LLC and its owners have less publicly available information, especially if the registered agent is not one of the owners. Registered agency is the subject of another one of my YouTube videos. Some of the advantages of a corporation are: corporations have been around for a long time, so the law is more developed and more uniform throughout the United States. Corporations are better suited to large numbers of owners. It is easier to sell and transfer stock rather than memberships. For companies with different types of ownership levels and interests, it is probably easier to set up and to manage a corporation than membership interests in an LLC. Corporation bylaws rarely require capital calls, while LLC operating agreements more often require owners to contribute capital if the LLC needs money. I hope this video is helpful to you. Whichever business entity you choose, I wish you great success. Our firm, Gross & Romanick, has extensive experience in setting up corporations throughout the United States. If you need a lawyer to help you make the decision or to set up your legal entity, please consider our law firm. You may learn more about us at our website, www.gross.com, or call us at 703-273-1400.